Good morning, Anima Madam. My name is Mr. Disha Siga, first semester LLB, Jarbam Gamlin Gop Law College, Jote. My roll number is 16. And as per your notification to prepare a visual representation of the assignment that I have been submitted, you know, as per your notification to prepare a visual presentation on subject on as per your notification to prepare a visual presentation on your subject law of tort with the topic a detailed note on the defense available in the law of tort in case of tort, sorry. So here I start. Number 1, introduction. Meaning and definition of law of tort. Law of tort owes its origin to the common law of England. The subject is well developed in UK, USA and other advanced countries, but in India it is in the process of development. It is not codified, so Indian courts apply the principle of justice, equity and good conscience. The expression tort is of French origin. It is derived from the Latin word tortum, which means twisted or crooked, that is deviated from straight or right conduct. It is also equivalent to the English word wrong. The affected person is called aggrieved or injured, and the person who commits tort is called a tortfeasor or wrongdoer. The aggrieved party can institute an action against a tortfeasor in civil court. Point number 2. Highlights about some torts and liabilities. Number 1. Trespass. The meaning of trespass is violation of moral or social ethics or wrongful entry on the real property of somebody whom you don't know. The trespass has got three important things or three important acts that combines to form a trespass. Number 1, assault. This can be found in section 351 of IPC. Another, battery. This can be found in section 350 of IPC 1860. Another is mayhem. A relevant citation for this mayhem can be found in Hearst versus Pictures Theatre Limited 1915 1KB 1. The second famous tort, the act of tort, is defamation. The term defamation means injury to the reputation or the character of a person. It is a dual wrong, that is, both tort and crime. There are two kinds of defamation. Number 1, libel. About this libel, we can have the citation and we can know about it in the case of Yusuf versus MGM Pictures Limited 1936 or 1934 50 TLR 581. The second of the among the defamation is slander. Its citation can be found in Villa Moda General Trading Co. versus Georgia Fashion Private Limited on 1st February 2005. Its equivalent citation can be found in 2005 3 BOM CR 41. Number 3 of the number three of the famous among the tortious actions are negligence. It's a kind of omission. It means, negligence means where a person has a duty to take care and the duty is not, and the duty or the care has not been taken, resulting in injury to another. A case relating to this could be found in V. Kishan Rao versus Nikhil Super Speciality Hospital, dated 08 March 2010. Apart from being liable for such direct torts, the people are also liable for torts which he haven't committed directly, which strict liability and absolute liability. Number 8, strict liability. A duty which renders a man liable without any fault of his and irrespective of any consideration or intention or negligence on his part. The case relating to this liability can be found in Raylan versus Fletcher, 1868, LR3, HL 330. Another of the liability that comes under tort is absolute liability. It is a standard of liability found in tort and criminal law. It is a standard of legal liability found in tort and criminal law of various legal jurisdictions. To be convicted of an ordinary crime in certain jurisdiction, a person must not only have committed a criminal action but also have a deliberate intention or guilty mind, that is mens rea. Now the point number 3 of my presentation is defenses, which is the dark or the main point that relates to this topic, the available defenses for tortious action. Now the first thing is that the available defenses should be utilized according to the types of tort and facts in the case. That is number 1, acts of God. Under the defense we have got act of God, the act which cannot be foreseen by any amount of human ability and skills, and even if foreseen, it cannot be prevented by any means of human care and skills. For example, earthquake, storms, etc. The reference for this particular defense can be found in the case Nicholas versus Marshland, 1875, LR10, EX255. Now, another of defense is that I, as a defense, can use the term that is the plaintiff's own fault. Now, if there is a fault on the part of plaintiff, the defendant is not liable. The case reference of this defense can be found in Ponting versus Noax, 1894, 2 QB 281. Another of defense is number 3, malicious act of stranger or the third party. The malicious action from the third party which does not belong to the case, but belong to the plaintiff either or to the dependent. If he acts badly, wrongly, with wrong intention, the defendant is not liable if the injury caused to the plaintiff is due to the malicious act of stranger. that is a third party. The reference to this case, to this defense, can be found in the case Vox versus Juve 1879 for EXD 76. Now, port number of defense that we have is consent of the plaintiff or the common benefit. The rule does not apply if the dependent keeps the things on his own land with the consent of the plaintiff. Number 4, consent of the plaintiff or the common benefit. The rule does not apply if the consent of the plaintiff or the common benefit. The rule does not apply if the dependent keeps the things on his own land with the consent of the plaintiff and the defendant. For example, water tank for the common benefit of the plaintiff and the dependent. The reference to this defense can be found in the case Peters versus Prince of Wales Theatre Limited, Birmingham, 1942, under clause 2ALLER 533. This is the coding number. Now, the last of the defense that we have in case my client has been charged of committing a tort, then the last option that I have is number 5, statutory authority. If any act done under the authorization of the law or statute, like the government of a country or a state government, causes any damage to a person, it has a defense to an action for tort. The case reference, this term can be found or highlighted in the case Green versus Chelsea Waterworks Co. 1894 70 LN 547. Moving to the end. Number 4, conclusion. Thus, good defense will depend upon the good amount of knowledge and understanding about the given situation and facts, and their good interpretation in the favor of defense, besides utilization of available defensive material wisely. So, with this word, I would like to share the sources from where I have gathered my information, from where I have been able to prepare this presentation. It is about a bibliography. The information is from Dr. B.K. Benya's book, and his book name is Law of Torts, including Motor Vehicle Act and Consumer Protection Act. It is the 23rd edition 2017 book. The book has been published from Allahabad Law Agency. Furthermore, for more detailed analysis and information, I have consulted www.google.co.in. With these few words and this presentation, I would like to stop my presentation. May my madam have a very pleasant day. Wish you good luck, madam, and thank you for giving me this opportunity.